So today we are going to discuss about the other rights, we other categories of rights, and if time permits, we will also look at two specific theories of rights, and that would be all with respect to rights. So I think we had completed till this positive and negative rights. So, if positive and negative rights are clear, then we'll proceed to another category of rights, okay? Way of categorizing rights, and that's known as rights in rem and rights in personam, okay? Now, this is something you already have an inkling about because you have heard these expressions enough. And we have also discussed this categorization recently in the context of Hofeldian, jural analysis. So rights in rem was, understood earlier, okay, as rights that you have with respect to things, okay, with respect to things. So your right with respect to your mobile phone, your laptop, your land, and all those, okay, rights with respect to things, okay, uh, was understood as rights in rem. Res means things, so rights in respect of things, okay. And rights in personam, as the name itself suggests, okay, um, meant rights that you have in respect of persons. Now I'm not talking about persons as property, okay. So you may have certain claims as against other specific persons, okay. So specific persons, that someone owes you certain money, so you have a right that others pay you money, okay. So this right that you have is not with respect to thing, okay. It's just that certain monetary value is owed to you, and that is to be paid to you. So those kinds of rights, okay, are rights in personam, or it could be other kind of rights as well, okay. That um, so I hope this basic thing is clear, that so right not to be assaulted, okay. Now that's a right, okay, that you have, okay. It's not as against you, as against any property, but it's just that others have a duty not to assault you. Now there's another way in which we can understand the same thing, and it gets us in confusion. Now in today's time, okay, we do not understand it this way. We understand this categorization in a little different way, and it makes it more clear when we understand this distinction in that sense, okay. So in today's time, rights in rem are not really about right with respect to thing, okay. It's more appropriately about rights that you have as against the rest of the world, okay. A right that you have as against the world. Now I told you that you have a right not to be assaulted, okay. Now that's a right in rem then, clearly, isn't it? I mean, everyone else has a right not to, a duty not to assault you. So this is the sense in we understand the word now, okay. Rights in rem, rights that you have as against the rest of the world. But historically, it was understood in terms of things. So any property right would be considered as rights in rem. Any other personal rights, okay, if any individual has any duty with respect to you, then that would be considered as a right in personam. But today it is like this, okay. Right in rem are the rights which you have as against the rest of the world, okay. And rights in personam are basically specific obligations, okay. That one specific it creates specific duties. So you are owed money, others are to pay you money. So it's a relation between A and B, okay. So all those Hofeldian examples that we could think of would be examples of rights in personam. Now, this I hope is clear. Now, why is that? The this distinction is till now it's clear. Now we can also look at it from that Hofeldian perspective. And if you were to ask hopeful, or if you were to go by his approach, he would say that, well, there is no such thing called right in rem. Okay, it just does not make sense to say that there is a right in rem. Why is it so? He says that legal relations arise between A and B, person A and person B. Okay, so it has to be determinate, being, isn't it? So it has to exist between person A and person B concerning a single act or omission. Okay, so that's how he defines. Okay, so the rest of the world is not a determinate, entity. It's not. So there cannot be such a duty that the rest of the world owes to me. Then what about rights in rem? How do we understand it? Then you would say that there are millions of, rights in personam with respect to you. So it could be either with respect to action or with respect to inaction. But as you will see, rights in rem are mostly negative rights, okay? And rights in personam could be negative as well as positive. Okay, rights in personam might require that others do something, some specific person do something or do not do something. There is no problem with that. But you cannot expect everyone else to do something with respect to you. So it is understood in that sense, okay? But you can generally those talk about certain rights, okay, in the moral sense of the term, talk about rights of others to do something with respect to you. But if you were to understand it in the legal sense, we see that rights in rem are more, can be, understood as negative rights. Okay, so what others ought not to do. So, for example, with respect to your property, okay, if you have a property, others ought not to enter your property. Okay, the duty does not say that others ought to enter your property. Duty involves others, inaction. Others ought not to enter your property. So that's the kind of distinction that we see. Okay. Now, so that's the similarity that you see kind of, there is, okay, between rights in rem, rights in personam on the one hand, and negative and positive rights on the one hand. So rights in rem are negative rights, and whereas rights in personam could be both negative rights as well as personam rights. And rights in rem, if you go by the Hofeldian approach, you see that there are many rights in personam clubbed together. Okay, so that's basically the distinction between rights in rem on the one hand and rights in personam on the other. Okay, so the earlier understanding was that rights in rem basically refer to real rights. So with respect to thing, with respect to property, rights in personam would mean personal rights, rights that didn't have property value. Okay, but today the understanding is different. Today it is like rights in rem is understood rights that you have as against the rest of the world. Okay, so usually it's going to be property like rights, okay, but not necessarily only property like rights. Okay, and you see that rights in rem are like more like negative rights. On the other hand, you have rights in personam. Okay, it could be proprietary as well as personal rights. So it's not necessarily only personal rights, rights that doesn't have property value. It could also be proprietary right in personam. Okay, that is also possible, and it could be both positive as well as negative. So that's the distinction between rights in rem and rights in personam as we understand it today. So is it clear? Am I making sense?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Oh, okay, so let's proceed. Before we go ahead, there are other terms that you would come across. You might hear about yas in rem. Okay, as traditionally understood, yas in rem was traditionally understood as a right with respect to thing, and yas in personam was traditionally understood, or yas ed rem, you can say, traditionally understood as right with respect to person. But the meaning has changed, as I explained to you just now. The next category is proprietary and personal rights. Okay, proprietary and personal rights. So this makes it very clear. Okay, this should not be confusing at all. Okay, But this nonetheless raises certain confusions. But if I explain it, this will make it clear for you. And you'll see that you don't even need to go back and read these again if you understand it now. So the next category is proprietary and personal rights. Okay. So as the name suggests, proprietary rights would involve rights that have some kind of property-like value. Okay, it's proprietary. Okay, I'm not saying that it's proprietary right in rem or proprietary right in personam. Well, that was there in the previous category. We discussed that. So as long as it is proprietary right, something that has property-like value, okay, something that is about monetary value, worth in money, okay, you can say that those are proprietary right. Okay, I'm not referring to merely property. Okay, it could also include proprietary obligations. Okay, so so what is the difference? So when I talk about property, you usually understand it in terms of land, building, or things like that. Okay, your mobile phone, your laptop, your other possessions, you understand property like that. Okay, now when I talk about proprietary right, it is not to be restricted to only things. Okay, it could also include other obligations, proprietary obligations. So what are those? Someone owes you a money. Okay, or a judgment, or you are the judgment creditor. Okay, and so whatever. Okay, if it has proprietary value, if it is worth money. Okay, so for example, damages to be paid to you. Okay, if it is worth money, okay, then those are considered as proprietary right, whether they are in rem or in personam. Okay, so they are considered as part of your estate. Okay, so your estate consists of everything that has proprietary value and it belongs in you. Okay, so that's your proprietary right. As opposed to this, personal rights are those, okay, which concerns with your status. Okay, I'm not talking about your monetary status though, I'm talking about your personal status. Okay, so personal rights, when we make this distinction between proprietary and personal rights, now the personal rights refer to all other rights but proprietary rights. So it essentially refers to your status. Okay, so as I said again, not to be confused with your monetary status. Okay, your personal status. Okay, whether you are the father, whether you are the son, whether you are the citizen or non-citizen, whatever. Okay, all those would come under your personal rights. Okay, so that's basically the distinction. Proprietary rights are worth proprietary value, that is they are to be understood in terms of worth in money. Okay, so that would include your wealth. Okay, and proprietary well-being. Okay, so that's what proprietary rights are. Okay, now proprietary rights definitely are part of both public as well as private law. Okay, as opposed to this, as I told you, personal rights are not of economic value as proprietary rights are. Personal rights are more about your personal status. So if you are a minor, can you enter into a contract? Can you enter into a marriage? All those questions determine your personal rights, whether you are a citizen, non-citizen, etc., etc. Whether you are imprisoned or you are free, all those factors determine your personal rights. Okay. So, however, as I told you, status is also traditionally understood as your monetary status, but that's not the one. I'm repeating again, not to be confused. I'm not referring to those status. I'm merely referring to your personal status. Okay, that's the only one I'm referring to. Okay, so your personal capacities, incapacities, all those come under your personal rights. Okay, so that's the distinction. Proprietary versus personal rights. So, am I making sense? Is it clear?
Yes. Okay. Yes, sir.
Okay, so these are very simple explanation. The next category that we have are rights in re propria and rights in re aliena. Okay. Now, when we talk about this right, we are concerned only about property rights. Okay, when we talk in terms of rights in re propria and rights in re aliena. We are concerned only about property rights. Okay. Now, what are they? Okay. Now, understand it like this. Okay. Rights in re propria are the rights that you have with respect to property that belongs to you. Now that I'm just getting you confused here. Well, earlier you said that, well, there is no property right, and those are merely a bundle of different rights, liberties, powers, immunities, etc. But even underlying that, we are referring to certain thing that predominantly belongs to you. Okay, so rights in re propria are like with respect to those kind of rights. Okay, so what are those? So if you own a piece of land, okay, your rights there are rights in re propria because you are the owner of that landed property. Okay, so your rights in re propria, it properly belongs to you. So with respect to property that belongs to you, as opposed to this, there could be rights in re aliena. So these would be those rights, okay, which are owned by someone, okay, as against the owner of the property. Okay, as against the owner of the property. Okay, so what could those be? So for example, someone might have a right of way, okay, over the land that is owned by you. Okay, now the land is not owned by the person who has the right of way. So here the property belongs to someone else. Okay, someone else. So we call it right in re aliena. Okay, so what happens is that there are many terminologies that we use here. Okay, so how are these rights connected here? Okay, these rights, as I'm talking about, the rights are connected not by person but by property. Okay, by property. So for example, there's a piece of land and there's an adjacent piece of land. Okay, a right is acquired by the person who owns the adjacent piece of land of way over the other piece of land adjacent to it. Okay, that right is with respect to that property. Okay, it's connected with the property. Subsequently, someone else buys that property, that owner will also now get that right of way. Okay, so the right goes with the property. Okay, now there are certain terminologies that we need to understand. Okay, so there is a word that you need to understand. Okay, so I'm referring to property here. Okay, one upon which the burden is imposed, the other that imposes the burden. Okay, so we understand it as encumbrance. Okay, encumbrance. Okay, there is one particular property over which the encumbrance is imposed. There is another property that imposes the encumbrance. Okay, so one is subjected to encumbrance. Okay, and another subjects another property to encumbrance. Okay, so that is also something that you need to keep in mind. Okay, and the property that imposes the encumbrance is known as dominant tenement, and the property upon which the encumbrance is imposed is known as servient tenement. Okay, so one has dominant right, other one has servient right. Okay, so the person who possesses rights in re aliena has the dominant right. Okay, or should probably should not use the term right here. The person who owes who has the land that subjects the other property to that encumbrance is known as the dominant tenement, and the property upon which the encumbrance is imposed is known as servient tenement. Okay, so as I told you, the encumbrance here concur with the right encumbered. Okay, so the right goes, this encumbrance goes with the property. Okay, it is not about the person who owns it. Okay, not about the person. So if the dominant tenement, okay, is owned by someone else, okay, as opposed to who's owning it now, that someone else will also acquire those same rights, because those rights will go with those tenements. Okay, so that's basically the idea of rights in re propria and rights in re aliena. So the rights that owner of a property has over his or her property are rights in re propria, and rights in re aliena are those rights which are owned by someone else, okay, over the property that belongs to someone else. Now, so far I explained it only in terms of two property which are adjacent, okay, but it need not be like that. It need not be like that, okay. There could be other times as well, other situations, other examples where the same thing could happen, okay. So so what could those be, okay? Other situations could also arise, okay, where it's not necessary that the two properties are adjacent, okay. Now, for example, take example of lease, okay. So I am the owner of a particular building, okay, and I have leased out a particular room, or floor of that building to person A, okay. Now I am the person who owns that property, so I have rights in re propria, and the person who has now that possessory right, okay, one right has been transferred, okay, the right to possession, okay, and use, obviously, has been transferred. Now the property though does not belong in that person, okay. So that person, okay, the lessee here, okay, or you can say the tenant here, okay, has a right in re aliena because the property does not belong. The same could happen when it comes to securities, mortgages, okay. But then mortgage could happen in many different ways. But generally the idea is that the person who has the property, who owns the property, okay, has the rights in re propria, okay, and that property is given to someone else as a security. So that person does not have ownership in the property. That person now has the property only as a security against money that has been advanced to the party A, okay. So in that situation as well, you can say that here the mortgagee has the right in re aliena, and the person who has mortgaged it, the mortgager, has rights in re propria. So these are some examples of rights in re aliena and rights in re propria. So the basic distinction here is this, okay, that rights in re propria are the rights which you have with respect to property that is owned by you, and rights in re aliena are the rights with respect to property, as I said, okay, not personal, not other kind of personal or status based right, only property right. So rights in re aliena are those rights which one has in property that is owned or belongs to someone else, okay. So that's the next category of rights. So did I make sense? Was it understandable? Was the distinction clear?
Yes, sir. Yes, sir. Yes, sir.
Okay, so
Sir?
Yeah, Sumit.
Sir, in rights to re aliena, you said that right goes with property.
Both are cases of proprietary right. Both are cases of proprietary right.
For that.
Your voice is not clear.
Sir, you said that right goes with property. Is there any legal maxim for that?
Sorry?
So he's asking, is there a legal maxim for right in property?
Rights in what?
Property.
What maxim? There are many maxims with respect to property. Which one are you asking about? I don't know of any specific maxim here, but the idea is this, okay? The right goes with the property, okay? The right goes with the property, okay? So I don't know, maybe there is nothing that comes to my mind at this stage, but with respect to these rights, okay, these category of rights that I'm talking about, okay, rights in re propria, rights in re aliena, the right goes with the property. So let me explain to you how that works. So for example, tomorrow I buy a piece of land, okay, particular piece of land. That land could be subject to security, okay. So maybe that land has been mortgaged, okay. So there are certain encumbrances imposed on it, or maybe someone has a right of way, or maybe the land has been leased, okay. So I, without doing all those inquiries, okay, I buy the piece of land. Okay, now when the land is bought by me, will I only get the land, or will I also get those encumbrances, those liabilities imposed upon that land? So I do not merely get the land, the land also comes with those burdens, those encumbrances which are imposed. Okay, so when it comes to these encumbrances, those encumbrances go with the land. Okay, so when you buy a piece of property, it's your responsibility to ensure that there are no such encumbrances imposed. Okay, there are no such burdens imposed, and then if you find something, you can nonetheless agree to buy that property with those encumbrances. But as a okay, careful customer, that's what you ought to do. You need to check whether it is subject to encumbrances or not. Okay, so those rights go with the property. Okay, so I don't know, I can't think of any maxim at this stage, but if I come across any, I'll definitely let you know. Otherwise, I hope the distinction is clear though. Okay.
Yes, sir.
So
Yes.
these rights in re liena can be acquired through prescription. It could be acquired through lease, through security. So there are many different ways in which the said right could be acquired. So the next kind is principal and accessory rights. Now this is very simple. If you understood the previous one, I need not even explain this one. Okay, principal and accessory rights. Now think of the previous category that we discussed. Okay, so if you were the owner of the dominant tenement, okay, and there's a servient tenement adjacent to the dominant tenement that is owned by you. Okay, now if for example the dominant tenement is owned by person A, now when you go and now buy the dominant tenement, okay, from person A, when you buy the land, okay, the principal right that you acquire is in the land itself. Okay, you get the right with respect to the land itself. Okay, so that will be your principal right. Okay, now that's not the only right. Okay, because you bought the dominant tenement also imposes encumbrance on the servient tenement, whatever it is, right of way, light, whatever. Now along with the principal right, you also get those accessory rights. So that's the distinction. Okay, one is principal right, and whatever rights that you get along with the principal right, okay, are known as accessory rights. So that's the next category. So it's very simple. It doesn't need any more explanation than this. Now one more category is primary and sanctioning rights. Okay, now primary rights are the rights that you have primarily. Okay, so rights that your right that someone pays you some amount of money, your right that others do not assault you, your right that others do not enter your property, can be considered as examples of primary rights. Okay, now remember Hoefel says that when these rights are when these rights are interfered with, then the next set of rights do emerge. Okay, so for example, you are not paid the money that you are owed to, someone enters your property, okay, in violation of your right that others do not enter your property, that moment another set of right that becomes active now. Okay, and what are those? Sanctioning rights. Okay, so now you can compel the other person to pay you damages or restoration, etc. Okay, so those kinds of rights, okay, that protect your primary rights are known as sanctioning rights. So nothing difficult here either. The next category of rights are legal and equitable rights. Okay, and what are those? Now, this is something that we are going to study in a little more detail when we study the paper on law of equity and trust later on. But for now, and you already know what these are, okay, because you have studied this in your CLS paper. The rights which were historically recognized by the common law courts were known as legal rights, okay, and rights which were historically recognized by the Court of Chancery or Court of Equity were known as equitable rights. Okay, so So in today's time, we'll say that, well, legal rights basically are all the rights which are created here either under common law or under statutes. Okay, so those are legal rights. Now, do we have equitable rights? Now, yes, obviously there are rights which are equitable in nature, but in today's time, at least in India, definitely in India, you have legal rights. Okay, you also had equitable rights which have now been considered as legal rights. Now this categorization is important only in the context of history. Okay, that historically the rights which emerged from common law court are known as legal right, or the rights that emerged from statutes enacted, laws enacted, and legal rights, and rights which emerged, which had their origin in court of chancery, court of equity, are equitable rights. So that's another category. And the last one that we are concerned about is the vested and contingent rights. Okay, then this is also quite easy to understand. Okay, now what are vested rights? Vested rights are those rights, okay, where all the requirements, okay, which are to be fulfilled for the right to be vested in you, have happened. Okay, so if it is like that, so for example, if you buy a piece of land, it is to be, in the written form, it is to be signed, attested, registered, whatever requirements, legal requirements have been laid down. If everything is fulfilled, okay, everything is fulfilled, then you become owner of the property. And once the legal requirements are fulfilled, you have a vested right. Okay, however, if there is a right, okay, which is subject to, okay, certain certain uncertain event, okay, okay, happening or non-happening of certain uncertain event, okay, then there is an element of chance, isn't it? Okay, there's an element of chance. So if it is of that sort, so it's a case of contingent right. So for example, you transfer property in favor of a B for life, okay, then in favor of C if C outlives B. Okay, in such case there is a chance that C outlives B. Okay, and if that happens, then obviously the right becomes vested once that happens. Okay, but if C does not outlive B, then the right does not belong in C. Okay, because C fails to fulfill the condition here. So there is a chance, okay, there is an element of contingency happening or non-happening of something. Okay, so if it is of that sort, then it is known as contingent rights. Now, if the right is based on happening of a very certain event, an event that will definitely happen, then obviously it's the case of vested right. So I'm talking about happening or non-happening of a specific uncertain event. Okay, things that could happen, things that may not happen. So what are those? Okay, so for example, C has to outlive B. Okay, if such contingencies, okay, chances are there, then the rights which are required are not vested but contingent. But nonetheless, these are rights. Okay, apart from the contingency, these are nonetheless considered as rights. Now, there are other situations which might give you the impression of them being a case of contingent rights, but they are not. Okay, let me give you an example that will explain it. Okay, now for example, A creates a will, okay, and by virtue of that will, leaves certain property in favor of B. Okay, now whether it is a case of vested right or a contingent right, what kind of right is it? Can you explain to me? What kind
Can you repeat the question?
It's very simple. So A, creates a will, okay, and by virtue of that will, gives certain property. It's in the will, okay. Says that in the will it's said that, well, I give this property to B. Okay, I leave this property for B. Okay. Now A has not died yet, okay, but merely has created a will. Okay, he hasn't died. Okay, you know that a will becomes effective only after the person who creates the will is dead. Okay. Now But in that will, certain interest in property has been created in favor of B. Okay. Now, what kind of right has B acquired? Is it vested or is it
So
contingent?
it's contingent right.
So Harsh thinks that it is a contingent right. Sumit thinks that it's a vested right. Ashu thinks that it's a vested right. Yes, Sumit, tell me.
It's a vested right, as it is certain for every human being to die one day.
Well, I think.
But sir, he's not yet dead and he can change his will.
But he will definitely die one day, wouldn't he? And he doesn't say that, if you outlive me, he does not say that either. So that contingency is not there, and it is sure that, A will die one day. At least for now, that's the case. So there is a surety. And many are saying that it's a case of vested right. Why? It has been created by virtue of the will. Now, here's the thing, okay? We make these mistakes. In fact, both sides made the mistake here. But there's nothing, I gave you a trick question, and that's why, you made this mistake. Okay, so blame is upon me. Now, the choice is not between A and B here. The choice is not between vested and contingent rights. The right answer here is that there is no right whatsoever which has been created. Okay. It does not create contingent, right. Obviously, it's not a case of contingent right. A is definitely going to die someday. Okay. So there is no case of contingency here either. Nor does it create any vested right. Okay. Why does it not create a vested right? Because A can any day add a codicil or write or draft a completely fresh will by virtue of which can undo the interest that remove the statement that says that I leave this interest in favor this property in favor of B. That is very much within the power that A has. Okay, so when a will is created, there is no right whatsoever, either vested or contingent, created in favor of B. Okay, because in that situation, a vested interest is there in favor of B only on the happening of only on the death of A. Okay, but A very much has the power now to remove it. Okay, remove the interest which is left. Okay, so in favor of B. So there is no question of either vested right or a contingent right. So the choice was not between either vested or contingent right. So here something else was there, and that is known as space successionist. Okay, there is a chance of succeeding. Okay, there is a chance of succeeding. Okay, to certain property. Okay, so that's merely a case of chance. Okay, it does not even create a contingent interest, let alone vested interest. Okay, now if A now dies after leaving the will, okay, so after that, obviously the other person will now have a vested interest subject to fulfillment of other legal requirement. Okay, that is not the concern for us. But it does not even create a contingent interest. Okay, so there is no right created whatsoever. Okay, there is merely a space successionist. There is a chance of succession to the property. Okay, and that's known as your case of testamentary succession. Okay, so the term in this particular case is space successionist. Okay, so it does not create either what do you call it, contingent or vested interest. So that's the case. Okay, so I hope you understood this as well. So is it clear? Did I make sense?
Yes, sir.
Okay.
Yes, sir.
So
Sir?
yes.
Sir, I have a doubt, sir.
Yeah, tell me.
Sir, you are saying that it's neither a contingent right nor a vested right.
Mm-hmm.
My doubt is that if I create a will towards against someone, then sir, it's contingent on me that whether I am going to create a new will or not. So, sir, that depends very much on my contingency to create new will or not. So I think it should be
No. Here's the thing, okay. this person who has created the right still have full say, okay, still have full say in whether the other person will be able to acquire anything, okay. So until the person dies, this thing has no value, okay. So there is no contingency here, okay. I said happening or non-happening of a specified uncertain event, but when it comes to contingent, right has been already created and the creator cannot do anything about it right now. Got the idea? The creator can now do nothing. So for example, I own a property, but I entrust it to you, okay? I entrust, so I create a trust in your favor, okay? And you hold that in trust in favor of B, okay? Okay? Now when I, in favor of B, and subject to it become vested in B when if B becomes, for example, major, okay? So that's the contingency. B has to become major. Now B has to be a major, okay? So that property becomes vested in B only if B attains majority. If B does not attain majority, then does not get the property. A contingency has been created that, B has to, be major, otherwise does not get the property, okay? Now, you see that the interest has nonetheless been created, okay? Interest has nonetheless been created. In this particular case, this person who has created that so-called interest can very much undo the same thing, okay? Whereas when the trust has been created, once the trust has been created, the creator cannot do anything about it. So the uncertainty is now of certain other event, okay? Not that, well, the person who has created the interest will take it back. No, not that. Whereas in case of will, that's very much the case, okay? The person who has created the will can very much make another will so as to negate the previous one. So it does not create any interest, whether vested or contingent in this particular case. That's why it's merely a case of spes successionis. So I hope that's clear now. Did I make it clearer this time? Okay.
Yes.
And then okay. So that's a case of spes successionis, and those were the examples of vested and contingent rights. Okay. So these were the different categories of rights. So we will now proceed to yes. Any other question? Okay. So let's now proceed to two theories of rights, okay? And those are known as will and interest theories of rights. Now, we have studied enough theories of right, and why the hell do we need more theories of rights? Well, these theories, tell us about something else, okay? We are not concerned about moral theory, etc. and all that, okay? These two theories, that is will and interest theory of rights, okay? They tell us about something else. So I will share a link with you right now. So click on it and you will be able to go there and keep the link open and read from here. Okay, so it's described pretty well here. Okay, in this link, you jump to the portion that deals with will and interest theory of rights. But let me introduce it to you. And it's also there in the book by the name Nigel Simons. And I do not have the book with me as of now, but the moment I get hold of it, I will send the relevant portion. But this is also very nicely explained in this particular link that I have shared with you. So we are concerned about will and interest theory of rights. Now, what are these theories? Okay, so these theories basically tell us about the function of right. Okay, what function does right play? In other words, what do rights do to those who have them? Okay, so what do rights do to those who have them? Okay, and there are two different functions that rights play that we will see based on the approach that we take in understanding. Remember, even earlier also we made this distinction. Some who talk about rights in terms of power, capacity, etc. The others who talk in terms of interest. Okay, so that's in the very beginning when we discussed about the definitions, you see that this is where it takes us. Okay, let's start with the will theory. Okay, now what does it mean? It says will theory. So it means when someone has rights, okay, someone exercises will, okay? That someone is a small scale sovereign, okay? Small scale sovereign, not referring to Austinian sovereign, but with respect to certain things, with respect to certain matter, that someone is a small scale sovereign. So that someone gets to exercise a choice, okay? So the purpose of, okay, the function of rights, okay, the purpose of rights as per will theory is to protect individuals' autonomy, okay? That's the will theory of rights, okay? It implies, okay, one's discretion, okay, one's control over another's duty. So we know that when I have a right, someone else has a duty to do or not do something, whatever it is, positive or negative, whatever, okay? Now, will theory says that I have a discretion on person B, okay? I have a control on person, B, who has that duty, okay? Who has that duty. So will theory basically defines rights, okay? Function of rights in terms of power, okay? You exercise some kind of power, some kind of control, okay? Some kind of discretion. So that's will theory for you. It protects your choice, it protects your autonomy. So when I have a right, I basically have the power to ensure that the other party, fulfills the requirement of the duty. Now, when I have the discretion, when I have the choice, okay, it means that I can also waive the right, okay? So I can also waive the right. So one of the implication of understanding rights in terms of this will theory of right means that I can, ensure that the right duty is performed. I also have the power to let it go, to waive the right, okay? So waivability, okay, is a quality that you see in examples of, in case of will theory of right, okay? So this would mean, when we talk about waivability, okay, this would mean that there are no rights which are unwaivable, okay? There are no rights which are unwaivable. So every right, in every example of right, okay, as per will theory, it would mean that you can waive those rights, okay? So no rights, okay, are unwaivable, okay? You can waive all the rights, okay? Now that leads us to some serious problem, okay? And what are those? So there are many examples, okay? One very prominent example would be, for example, right not to be enslaved, okay? Right not to be enslaved, okay? So you have a right that others do not enslave you, okay? Now this is a right which seems to be unwaivable. You cannot give it up, okay? You cannot give it up. If you give it up, others will turn you into a slave, but that's not what actually happens. So it seems to be a case of unwaivable right, okay? So how does will theory account for this kind of right? Will theory says that it has to be waivable. So will theory is one of the defects that you will come across when it comes to will theory is that it's not, because it is waivable in nature, it's not able to account for rights which are unwaivable, rights that you cannot give up, okay? So it protects your autonomy, okay, and it basically focuses, it basically emphasizes on the element of you having free will, you having choice, you having autonomy, okay. So you become a small scale sovereign. Now, as opposed to this, there is another theory known as interest theory of rights. Now, interest theory of rights, okay, are different. It does not bother itself with this idea of you being able to exercise choice, you being capable of willing, okay. Now, why do we need the other? Obviously, we need the other because interest theory is able to accommodate much broader range of rights, okay. So there are certain other cases that will theory is not able to, account for, okay. What will those be? So you will come across, okay, when it comes to will theory, you will come across people or entities which are not capable of willing, okay, which are not capable of making choices, okay. So someone who's bedridden, comatose, okay, a little baby, okay, or animals, okay, we think that they're not, at least in the case of person who's comatose, others maybe we might disagree, but at least someone who's comatose, okay, who's in coma, you would say that, well, that person is not able to exercise choice, that person is not able to exercise any autonomy or will, okay. So do they have rights then? So you see that will theory would say that, well, they don't. Why not? Because they're not capable of willing. But that's not how we understand rights either. Okay, we say that person who's bedridden, who's comatose, okay, or maybe when you are asleep, you're not able to exercise your choice then. So does that mean you are not able to have rights? So will theory would say that, well, will theory will have difficulties. Okay, why did I give you example of being asleep? Now a person who's comatose will not be able to make that choice at that moment, okay, but there is a likelihood of that person regaining consciousness, okay, coming back to senses. Maybe they will. So many will theorists would say that in this particular case, okay, just like in the case of sleeping, someone will get up sometimes, or the comatose person would maybe come back to consciousness, okay, eventually. So because of that prospect, we consider at this instant that they have right. But then you see that, well, that's not very satisfactory example, okay. We have many other examples where even though they're capable of living their lives, but they're not capable of making choices in the way we understand humans making choices. Clearly in case of rights of animals or little baby, infant, okay, they're not able to make the same choices, but law nonetheless protect, okay, or for that matter, okay, persons with mental disability, okay, in certain extreme cases, law presumes they're not capable of making certain choices. So do they become non-human? I mean, are they not capable of having rights? Then, well, these are the situations that will theory is not able to account for. And that's why you have another theory of right known as the interest theory of right, that is able to accommodate much broader range of cases of rights, okay, and that is known as the interest theory of rights, okay. So according to this interest theory, rights exist to serve certain interest, okay, certain relevant interest of the right holder, okay, of the right holder. You can also call it benefit theory. So rights are beneficial, okay, to the person who holds the right, okay. It protects, okay, your interest in something, but you may have interest in many different things, okay, okay. So what interest will be protected? So Joseph Raz says this, okay, about interest theory. X has a right if X can have rights, okay. So not everybody must have rights, okay. Legal qualification, disqualification may also be used, okay. So it's saying X has a right if X can have rights, and other things being equal, an aspect of X's well-being, to be understood as his interest, okay, is a sufficient reason for holding some other person or persons to be under a duty. So when the interest is sufficient reason enough, okay, a sufficient reason, then others are held to be under a duty. So interest theory says that rights basically plays the function of protecting your interest, but you know that not all interest, okay, the interest that gives sufficient reason, okay, so it could be legal reason, okay. So that's essentially the idea, okay, that's essentially the justification for rights, and that's the function that right plays, okay. It protects the interest that the right holder has, okay. So now here's the thing that it explains for, okay. So the problem that we came across with respect to will theory, one of the problems that we came across in will theory is the cases of rights which are unwaivable. Now, in this, if we go by this approach, we do not even come across those problems. So there are certain interests, okay, which are so important, as Raj would say, okay, which are so important that you are not allowed to, waive them. So, for example, you cannot give up your liberty for good and become a slave. Okay, so the interest is so important. Oh, the reason is so sufficient, as he would say, that it is not allowed to be waived. Whereas will theory would say that, well, you can give it up, you can waive it. So holder of a right, as per this theory, okay, in some cases maybe you would, but in some others, okay, saying holder does not have the moral power to waive or annul. Okay, so the approach here is very much instrumental. So you are better off. Okay, so the interest, okay, depends on the degree of the interest, sufficiency of reason, the degree of importance of the interest. Okay, that will determine whether you can waive or not waive. Okay, so the interests, okay, here, the rights here are instrumental in nature. Okay, so you are better off with those interests, okay, than not. Okay, and in some cases you are so much better off that there is no justification for it to be waived or taken away. Okay, so the interest theory is able to account for that problem that we came across, that flaw that we came across in will theory. Okay. However, there are certain problems that we come across even in interest theory. Okay, so we may come across rights. Okay, it came across cases where you have right, but you do not have any interest there. Okay, at least for you. Okay, for your own self, you do not have interest. Okay, or you may come across, you may have certain interests, but you do not necessarily have right there. Okay, now the second one is not very difficult. Okay, we say that only rights which are recognized by the law. Okay, now only the interests which are recognized by the law, that you can consider as a matter of right. So it's not really very problematic. But the other cases would be, of those where you have right, but you do not have any personal interest there. Okay. So in the reading that I have given you, you will see that, for example, they're talking about judges, judges being able to, adjudicate. Okay, if you try and understand. Obviously, adjudication would be a matter of power, but you can also understand it in terms of a right that you are entitled to decide. Okay, you are entitled to decide. Okay, and the matter ought to be decided. Okay, so you can think about it in terms of right. But if the judge has this right to decide the matter, okay, to adjudicate, okay, what is the personal interest that the judge has? The interest here is not really of the judge, but the interest which is being protected is of the the society as a whole. Okay, so you see that sometimes rights could exist even when there is no specific interest that the person supposedly having right has. Okay, there are many other such examples where rights are given. Okay, rights are given to one specific person. Okay, but the interest does not really belong in that person, but belongs somewhere else. Okay, belongs so for example, parent might have a right, okay, to care for their children. Obviously they have an interest there as well. Okay, but there are also cases of interests of the children which might also justify parents having certain rights over their children. Okay, so those are the situations that this particular approach is not able to account for. Okay, so there are many such examples you will come across if you read this particular reading that I have shared with you. Okay, and there are certain other approaches therefore which have been discussed. Okay, so many say that why do we have to choose between these two approaches? Okay, why either this or that? Why not both of them? Okay, so so anyway, so those are there. Apart from that, there is something known as demand theory and others. But I will stop it here. Please go ahead and read from the reading, and if you're clear with this, then you can go ahead and read other approaches. So there are other approaches, for example, those who talk about rights in terms of needs, and those who talk about rights in terms of demands. Okay, so there are many other approaches to understanding what right does to those who have rights. Okay, so that's it from my end with respect to this topic of rights.